Hello, everyone. Welcome to week 8 and chapter 8. This week, we're going to be learning more about the legal system. In this first video lecture, we're going to be covering the basic and fundamental parts of the United States legal system. Okay, as discussed, we're going to be covering healthcare law. And we're going to begin by talking about how laws are classified. We're going to be talking about public versus private, criminal versus civil. So, public law you can think of as criminal law, laws against the state, murder one, things of that nature. With private law, it's helpful to kind of think about it as contractual law. I have a contract with somebody that didn't stand up to it, and as a result, they're in violation of contract. So we have civil versus civil actions, if you will. So that's kind of the Reader's Digest version of public, private, criminal, civil. We have several sources of law. Sources can include constitutional, statutory, administrative, or common law. And these are addressed in your book, right? Constitutional is the thing that we're hearing a lot about in the news if you're watching CNN in terms of if a law is constitutional or not. So, very important concepts here. Now we'll get into the branches of the government. If you can remember your high school civics or government class, depending on how they classified it, we always talk about the balance of powers, and we talk about the three major branches of government. And this includes the legislative branch, which creates the laws, if you will, the executive branch that carries them out and executes them, if you will, and then the judicial branch, which is basically the branch that determines whether a law is constitutional or not, and precedents and all these other things. So, depending on what laws are broken, there are federal laws, right? And there's state laws. Let's take a look at the federal system first. With the federal system, we're talking about the US court system. These are the district courts, the circuit courts, and then finally the highest court where you can appeal a ruling to, which is the US Supreme Court. On the state side of it, we have the state court systems. And here we have trial courts, and these could either be limited or general jurisdiction, things like family court, things of that nature. And then we have courts of appeals or appellate courts. So in other words, there is a trial. I'm not happy with the ruling. I'm going to appeal it to a higher court, right? And then finally, at the end of the state court system is the state Supreme Court. Now, for those of you who are working in a union environment, you're probably familiar with the term arbitration and mediation. A lot of people view these things as basically the same thing, and they're actually quite different. They are both a way of handling legal disputes, right? It's a dispute resolution process, right? When we talk about binding arbitration, we're talking about an administrative law judge, right, who is picked by both sides, right? So in California, when we would get involved with this, the union and the employer, meaning the hospital or healthcare organization, would have a list of administrative law judges that they both agreed on, and they would both select one of them. And this administrative law judge would hear both sides, and he would make a binding ruling. Binding means that there is no way it can be appealed. It stands, right? That's it. A mediation is different. A mediation is not binding. So basically, both parties agree to go to a mediator who will hopefully find a way forward and hopefully find a mutually agreeable situation. But it's not binding. So, in that way, people, why would you want to have something that's not binding? For one, binding arbitration is a winner take all approach, right? And depending on who the arbitrator is, the union, or for that matter, the employer may not want to take a risk on that, right? The other thing is it's expensive, right? You have to pay for document discovery, you have to pay for the administrative law judge's time, and it's really not cheap. Mediation is definitely almost all the time a cheaper option. So, a couple of the players when a lawsuit erupts, a plaintiff, right? A plaintiff is the complainant. He is the person who is lodging the complaint, alleging some sort of violation of law or failure to abide by the terms of the contract or what have you. The defendants are the people who are being accused, and they can either answer it, they can have a counterclaim, cross claim, or what have you. So, important to keep in mind a plaintiff, the person who initiates it, right? If somebody countersues the defendant, who is the person that is being complained about, the party being complained about, chooses to countersue, right? That's kind of turning the tables on him and saying, I have some issues of my own that I want to bring to your attention. So, important to keep in mind the difference between a plaintiff and a defendant. And that's all I have for you. Come back and we'll talk more about the US system. Before we get into all those finer points, what you may want to do is consider reading all the glossary terms at the beginning of the chapter. That way, as you go through with the reading and watch the video lectures, it'll make a little bit more sense to you. I hope you find this helpful, and we'll see you online. Bye now.